Thank you very much, Eduardo. Thank you for your presentation. I'm indeed a senior advisor at the office of the OSCE representative on media freedom, Ms. Teresa Ribeiro. And my presentation, because I was given graciously quite a significant amount of time, will be split into two parts. The first part is what Ms. Ribeiro was about to say to you. Unfortunately, she couldn't come, and therefore she requested me to speak on her behalf. And second part will be my personal views on the topic from the with the angle of the right to truth, which I think is one of the core issues of the disinformation. Right to truth from international law perspective. Okay, sorry. So indeed, Ms. Ribeiro was about to say to you that it is a pleasure to address the participants of this of the conference on a very timely and important subject, and tackling the issue of disinformation by crafting efficient policies and legislation in line with media freedom commitments has been in the forefront of the activity of your office. Just this year, we had 2 expert meetings on this subject, and we plan to have several more. And actually, the 2 that we had, one was on the international law and disinformation, and another was on media self-regulation and disinformation, and all the materials, including videos of the presentations and presentations themselves, are on our website, and please look into them. They are quite useful, I believe, to those who want to study the issue of counteracting disinformation. While the issue of disinformation in the media has been around since the birth of journalism itself, the problem is more prevalent than ever in today's digital age. With the rise of internet and social media, disinformation is able to travel across borders unchecked, unverified, and at lightning speed. While there is no universally accepted definition of disinformation, 2 of them at least were presented before, and I will go back to those definitions, which doesn't make, of course, our job easier. There are some distinguishable characteristics and features. For instance, if we take the Brussels approach, the approach of the European Union as a starting point, disinformation involves verifiably false or misleading information that is created, presented, and disseminated for economic gain, or to intentionally deceive the public, and that may cause public harm. Public harm is a key element here, and does this include harm to media freedom? That's a question. Trust in news media, both traditional and online, rests in the search of the audience for accurate and fact-based information. In abiding by the principles of fairness and separation of facts and opinions, journalists build credibility with their audience. Therefore, by blurring the lines between false and true, disinformation undermines public trust in professional, quality journalism and its role in a democratic society. In short, disinformation seeks to destroy trust in the media. And when you destroy trust, you destroy the borders and the bonds that hold society together. The need to act is therefore paramount. Only recently, we have witnessed how disinformation can spread during the global health pandemic, and there were several presentations that today that touched upon this subject. Disinformation also threatens security that we hold dear here in the Organization for Security and Cooperation in Europe, OSCE, the security that we have worked long and hard to maintain and keep sacrosanct. Disinformation is successful. Disinformation thrives in regimes where independent investigative journalism is constrained. And it's probably best tackled through media literacy and with a vibrant, pluralistic, and independent media landscape. While disinformation in its own presents challenges to governments, so too do the responses and the business policies of the media platforms if they fail to respect human rights, if they fail to respect freedom of expression. States' responses to tackling disinformation are numerous, ranging from measures to disrupt the internet to legislation aimed at de facto censoring, punishing, or restricting disinformation, dissemination of information, and regulation of social media platforms. Let me be clear that in my view, in the view of the representative, tackling disinformation by restricting human rights is not the way forward. That is why we must ensure respect for international legal framework to protect our freedom of expression and opinion. And of course, the special rapporteurs on freedom of expression of the UN, Organization of American States, and the African Commission published a joint declaration on freedom of expression and fake news, disinformation, propaganda. And I urge the participants to look for international legal solutions to this information, to take a look at the joint declaration of 2017, because it contains general principles shared by 4 international rapporteurs on freedom of expression. While states have an obligation not to interfere with citizens' right to freedom of expression and opinion, businesses and private companies too must ensure that their policies and practices do not undermine human rights, trust in the public eye, in line with another very important document, United Nations Guiding Principles on Business and Human Rights. It has been shown that where media freedom and pluralism are guaranteed, self-regulation of the media and protected from governmental interference. Therefore, it is important in this regard to ensure the protection of human rights. By providing everyone with the tools to question and evaluate information that they receive, increasingly crucially, the sources of that information, we can help make societies more enlightened and resilient. One could call it a form of rational censorship or media self-regulation at an individual level. That is why the promotion of media and internet literacy must be a key priority in countering the harms of disinformation. And as such, should be promoted at all levels of society, from the educational system through to journalist organizations. In the end, Ms. Ribeiro wanted to wish the discussion today provide some useful food for thought as we move forward and continue to explore the topic, as well as examples and lessons learned with regard to current media regulation efforts. And in my second part, where I speak in my personal capacity, I haven't managed to switch on the presentation, but I promised to send it to participants through Eduardo. I would like to touch upon an issue, as I said, of the right to truth and right to lie, whether there exists such human rights in the current context of disinformation regulation. I raised 2 questions here. First question: is there a human right to receive truth from any person at any time in any context? Is there a human right to truth? And the second question: is there a human right to disseminate lies? Consciously, you understand you disseminate lies, but you still want to disseminate lies. Is there a human right to that? Are false statements unprotected when made to any person at any time in any context? Well, international law speaks about right to truth, but it speaks about right to truth only in a very, relatively narrow context, very narrow understanding of the right to truth. Right to truth is understood by international law as a state obligation to reveal to the victims and society everything known about the facts and circumstances of massive and systematic human rights violations of the past, including the identity of the perpetrators and instigators. This right to truth has first been established in the 1980s in the decision of the Inter-American Court of Human Rights in the case of Velasquez-Rodriguez versus Honduras. And that is the case about the numerous instances, hundreds of instances of so-called desamparados, or people who were kidnapped during the dictatorship in Latin America, and their fate has become absolutely unknown. They simply disappeared. who were the persons who kidnapped them, in paramilitary uniform or not in paramilitary uniform, what was the relationship of those persons to the government, what was the, most importantly, fate of those persons, was unknown to relatives. So in this case, Velázquez Rodriguez versus Honduras, Inter-American Court of Human Rights in 1988 established that the relatives have the right to truth, meaning that the state should do everything possible and almost everything impossible to discover the circumstances of the fate of these persons who were kidnapped. There was a similar case much later in 2010 of the same court in Gomes Lund versus Brazil, with the same logic, but in the case related to the separados in Brazil. That is not purely American thing, it's also a European thing, because the European Court of Human Rights in a decision El Masri versus the former Yugoslav Republic of Macedonia, the decision was taken in 2012, established the same scope of the right to truth. If we talk about the violations of human rights, again, massive and systematic human rights violation, there is right of truth to truth of the relatives. There was also a similar case about archives in Hungary, when the court said that the archives should be open so that the relatives could see on the violations during the communist regime. On a United Nations level, there was a study on the right to truth, which was published by the United Nations High Commissioner for Human Rights as early as 2006, which basically underlines that such a right in this particular sense exists. So we see that to some extent there is right to truth. Moreover, right to truth is very important in international relations. And intergovernmental bodies like the United Nations were for quite a while worried about what happens if incorrect statements are disseminated to another state. So we are talking now about international dissemination of lies. What should be done in such case? There is a very peculiar document, international document, which is still acting document, although nobody knows about it and nobody remembers it definitely. It's called International Convention Concerning the Use of Broadcasting in the Cause of Peace. It was adopted in 1936 by the League of Nations, but United Nations organization, when established, took over this international convention and proclaimed it as part of its documents. So by the International Convention Concerning the Use of Broadcasting in the Cause of Peace, the document says that the high contracting parties mutually undertake to prohibit, and if occasion arises, to stop without delay within their respective territories any transmission likely to harm good international understanding by statements, the incorrectness of which is or ought to be known to the persons responsible for the broadcast. Basically, the convention, I repeat, it is an acting convention, and some of the European countries are formally part of it. This convention prescribed that the governments should do everything possible to avoid dissemination of known lies, or if we talk about the private broadcasters, to do everything possible to educate private broadcasters that they have responsibility to disseminate only truthful information. As we all know, the basic principles of freedom of expression are in Article 19 of the International Covenant on Civil and Political Rights, and I will not repeat its text. I will just underline that it speaks about freedom to seek, receive, and impart information and ideas of all kinds through any media. And what is all kinds? All kinds probably also means true information and false information. This this Article 19 of the International Covenant on Civil and Political Rights, in its draft, and the covenant was negotiated in the United Nations for 20 years. It also envisioned at some point that limitations to freedom of expression will be in case of systematic diffusion of deliberately false or distorted reports which undermine friendly relations between peoples and states. In other words, the United Nations wanted to stop disinformation from one state to another state if it damages friendly relations between peoples and states. This draft provision didn't go through, mostly because of protests on behalf of United States and other Western countries. So now we have Article 19 as it says today, and such element as disinformation is not part of possible restrictions of disinformation, of freedom of expression, I'm sorry. Is there any, let's look at the same problem, but with a different angle. Is there any protection for lies to be disseminated? Can a person lie publicly through media, etc., etc.? In the report of the Special Rapporteur on Promotion and Protection of the Right to Freedom of Opinion and Expression of the United Nations, Irene Khan, it was already mentioned today by one of the speakers. This report titled Disinformation and Freedom of Opinion and Expression says, in particular, freedom of expression applies irrespective of the truth or falsehood of the content. And therefore, the prohibition of false information is not in itself a legitimate aim under international human rights law. So what she basically says that you cannot prohibit false information and believe that it has such prohibition has any grounds, legitimate grounds in international law. European Court of Human Rights had a very important decision, judgment rather, that touches upon the subject of false news and false information. That is the judgment in the case of Salov versus Ukraine, the decision of 2005, and the case.
We missed probably the last 30 seconds.
Okay, I apologize. Probably I pushed the button by chance. So the case of in case of Mr. Salov, the European Court of Human Rights underlined that Article 10 of the European Convention of Human Rights, as such, does not prohibit discussion or dissemination of information, even if it is strongly suspected that this information might not be truthful. To suggest otherwise, said the court, would deprive persons of the right to express their views and opinion about statements made in the mass media and would thus place an unreasonable restriction on the freedom of expression. There is also a very well-known statement of the European Court of Human Rights, which is very often quoted and is used in many decisions of the European Court, that freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population, such as the demands of that pluralism, tolerance, and broad-mindedness, without which there is no democratic society. There are also two cases which I would like to mention of the national high courts which protect lies. One case is a case that was adjudicated by the United States Supreme Court. That's the case of United States versus Alvarez, the case of 2012. In that decision, the United States Supreme Court said that false statements are not, by the sole reason of their falsity, only because they are false, can be excluded from the First Amendment protection of the United States Constitution. And the case itself was that Mr. Alvarez, in order to attract attention of the public to his words, falsely claimed that he has a military medal. so to gain some respect from the audience. He didn't have a medal. He was never awarded by the military, and the act, which the federal law which existed in the United States, prohibited such statements of having a military medal while not having it. And therefore, he was fined later on by the courts, and the United States Supreme Court said, no, that is unconstitutional, provision of the law is unconstitutional, and Mr. Alvarez should be charges against him should be dropped. Another case which relates to media and broadcasting actually is also very interesting. It's judgment of the Constitutional Court of the Slovak Republic in a case of MAK TV. MAK TV, that is a decision of 2014. MAK TV was broadcasting a news program, a night news program, during which one of the candidates, when interviewed live by the journalist, said, and by the way, my competitor, Mr. Whatever, has just took off his candidacy from the elections. That was not true, that was false, and by law, broadcasters in Slovakia should provide only truthful information. So the national regulator put a penalty on the broadcaster, which complained, and went up through all the instances possible in the judicial system of Slovakia, up to the Constitutional Court, which produced a very long and interesting decision, saying that, in particular, that the right to receive information includes the right to receive information both truthful, verifiable, and neutral, as well as fictitious, unreliable, untrue, or distorting truth, or presenting a particular viewpoint. In explaining why it made such a decision, the Constitutional Court referred both to Article 10 of the European Convention on Human Rights, but also to the circumstances of the case when any voter could find himself or herself whether the information was truthful or not, and that such information didn't or couldn't influence the outcome of the election in Slovakia. What is the legal most important instrument to fight untrue information? That is the right of correction and reply, and I don't mean particular national provisions that oblige a broadcaster or media outlet to publish correction or reply. This is more or less known case, known to many lawyers and journalists. But I would like to refer to another document which is forgotten, but de facto is de jure, I'm sorry, it is acting document, which is the United Nations Convention on the International Right of Correction. It was adopted in 1953. It entered into force in 1953. And first of all, it said that in the preamble, the convention said that it is not practicable to institute on the international level a procedure for verifying the accuracy of a report which might lead to the imposition of penalties for the publication of false or distorted reports. So there is no practical need to establish an institute which will decide whether information is true or false, at least on the international level. What the convention envisioned was that if media outlet in one state disseminates false information about another state, that second state has the right through the foreign ministry to demand from the media outlet publication of correction. If correction is not published within a stated period, I think it was 1 week or so, the foreign ministry of the second country has the right to request United Nations Secretary General to disseminate this correction through all means available to the Secretary General. To the best of my knowledge, this convention has never been used although I'm sure that there were many cases when false news and false information about another country is disseminated. The European Union Action Plan Against Disinformation, the first basic document which related to that matter, again, as I said already, understood disinformation as information which may cause public harm. And we heard today in the first part a wonderful presentation about what is public harm in the Georgian law, and in the Georgian law, public harm doesn't differ from public harm in many other countries. For the European Union, public harm includes threats to democratic process, which is basically elections, as well as to public goods such as European Union citizens' health, environment, or security. So it's narrow, but it's narrow to both the geographical scope and the types of public harm which are at least in the forefront of the attention of the European Union. To conclude, I would like to say that first of all, we should distinguish two forms of disinformation. Disinformation in the mass media. What about it? It definitely violates professional standards of journalism. If we look into any professional code of practice, into any professional code of journalism, you will see that probably in the first chapter, it speaks about the need for journalists to look for true information, and to deliver, disseminate only truth. And so it's unethical. It probably violates standards of the profession, and it should be dealt by the self-regulation bodies. Disinformation in the social media is more complex and more new and difficult problem. Apparently, so far at least, it is admissible if there is no harm to protected public interest, of which I spoke today. So to answer the two questions which I put in the beginning, is there an internationally recognized human right to receive truth? No, unless of specific cases of gross human rights violations. Is there an internationally recognized human right to disseminate lies? Yes, unless in specific circumstances, such as, for example, lying to the government or courts of law. So public harm in any discussion on legal regulation of disinformation is probably the contextually the most important element. Thank you for your attention.